Hi, my name is Andy Carlson, and today I would like to speak with you about affirmative action. Affirmative action is a hot topic today in our society. The purpose of this presentation is to take an objective look at affirmative action by reviewing the history, implementation, legal ramifications, and consequences of this controversial policy. Understanding affirmative action is imperative to anyone working or attending an institute of higher education or anyone involved in general education. The main question posed in this presentation is, how does affirmative action affect higher education, and should it continue to be practiced? We'll also answer the questions of why should institutes of higher education implement affirmative action? Does affirmative action help or hinder minorities? And lastly, is affirmative action legal? As far as the definition is concerned, first we should probably define what it is for clarification. And according to Cornell Law School, affirmative action is a set of procedures designed to eliminate unlawful discrimination between applicants, remedy the results of such prior discrimination, and prevent such discrimination in the future. Applicants may be seeking admission to an educational program or looking for professional employment. As far as history is concerned, what most people don't realize is the longevity of affirmative action. One common misconception is that it was developed and implemented before today's kind of political correctness that we have. It was actually signed into law on March 6, 1961 by John F. Kennedy when he signed the Executive Order 10925, which stated that whereas discrimination because of race, creed, color, or national origin is contrary to the constitutional principles and policies of the United States. At that time, President Kennedy thought that it was in the general interest and welfare of the United States to promote its economy, security, and national defense through the most efficient and effective utilization of available manpower by means of affirmative action, obviously. What is even less known by the general public is that affirmative action actually precedes the Civil Rights Act by 3 years, which wasn't signed until 1964. Civil Rights Act of 1964 is, if you remember correctly, is when it was made illegal for institutes of higher education to discriminate against students based on gender or race. Some statistics that we have here. The reasoning behind the implementation of affirmative action in higher education was to desegregate and to buck the trend of higher education basically being dominated by males, white males for that matter. The idea was to open the doors to minorities and women. According to the U.S. Department of Education, women have made very large strides and now constitute 56% of college student population. Minorities have also made great strides. From 1976 to 2014, the percentage of Hispanic students rose from 4 to 17%. The Black student population showed some modest growth from 10 to 14%. Native American from 0.7 to 0.8, and Asian or Pacific Islander from 2 to 7%. One question raised is, can all this be attributed to affirmative action and the Civil Rights Act of 1964? And some would say no. But the bottom line is that without these key pieces of legislation passed, it was no longer legal to discriminate against women and minorities as it had been in the past. So why are statistics important? Obviously, they show hard evidence that affirmative action has been effective in the increase in minorities and women in college. And the bottom line is that our country recognized and continues to recognize the fact that there was and that it was not a fair playing field, a level playing field. Hence, laws were enacted to protect and promote diversity in collegiate and work settings. As far as benefits are concerned, the benefits of affirmative action are numerous. The first is correcting income inequality. It is almost universally agreed upon that being educated leads to more earning capacity and social mobility, as well as usually a healthier and happier life. With undereducated and ill-prepared citizens, there are major repercussions. In theory, if students of color are continually going to be underserved, this country's economic problems will become even larger and more magnified with the rise in population. In the past, undereducated people could typically rely on blue-collar manufacturing and service industry jobs to earn a decent living. Obviously, we all know that's not the case any longer, with those types of jobs becoming fewer and fewer. What happens when undereducated adults can't find work? Obviously, they may resort to crime or other, means to subside. and become reliant on government assistance. So it's also proven that the chances of a student when the chances it is also proven that the chances of a student finishing college are greatly impacted by the educational attainment of their parents. So when minorities are educated, this increases the chances of their children being educated, and in turn gives them more social mobility. And then it's generational. Hopefully, then the next generation will also go to college. Diversity in a collegiate setting is another important reason for affirmative action. How can one learn about other cultures and things about how can we learn from others if we are just one group of homogenous people? If we're all just white, how are we going to learn about other cultures? The idea of diversity is that when people from various backgrounds come together, they're going to learn a lot about each other. Colleges and universities also act as a natural facilitator to promote dialogue by adopting affirmative action. When someone does not understand someone else's culture, it is typically because they do not know anyone from that culture. This can lead to divisiveness amongst groups because of a general lack of understanding from one another. With divisiveness at a boiling point in this country, as we just saw a week ago, it appears that our nation's future needs more diversity in order to better understand one another. It is also important to point out that without affirmative action, minorities and whites would still be separated in educational learning environments, making the nation even more divided than it already is. As far as legal challenges are concerned, since the inception of affirmative action, there have been numerous challenges of it. Starting in 1978, I think it's the Bakke case, was when a medical student claimed that he was denied admission because he was white and male. He ultimately did win his case, actually, in the Supreme Court because at the time, the school used a racial quota, basically hard numbers that says we are allowing this amount of minorities in. Several more cases continue to kind of narrow the scope of affirmative action and transform it into what it is today, which is basically a mission statement. Just kind of this broad concept or loose interpretation. Really makes it more difficult to challenge in court. And just recently, actually, it was challenged again. The Supreme Court verdict in the Fisher versus University of Texas case. And it was affirmative action was deemed lawful. And that was in 2016. Justice Kennedy wrote that the majority opinion in this case, and he said that a university's goals cannot be illusory and amorphous. They must be sufficiently measurable to permit judicial scrutiny of the policies adopted to reach them. And what Justice Kennedy is essentially doing is pointing out that universities' affirmative action policies are kind of vague and difficult to find, which makes them immeasurable, and therefore they cannot be scrutinized in court, kind of like we were discussing earlier. What this means is that critics of affirmative action will be pushing universities for hard data that is measurable, hence back to the 1978 case with Bakke, making these policies, again, vulnerable in the court of law. Now, whether or not institutions of higher education will have to abide by these new rules is yet to be seen, or if they'll be forced to do that. We'll see probably in the very near future. Another important side note is that states actually do have the right to ban affirmative action at their state constitution level. Since 1996, California, Washington, Florida, Michigan, Nebraska, Colorado, Arizona, Oklahoma, and New Hampshire have all banned affirmative actions, and others may follow this trend after the recent ruling in the University of Texas, like I was discussing. The conclusion is that there's overwhelming evidence to yes, this is definitely working. Since the inception of affirmative action, we've seen in higher education, millions of women and minorities have been afforded the opportunity to attend college. Decades previously, that wouldn't have happened. So obviously more opportunity, the diversity that I talked about, there's just a lot of great things happening. So thank you for your time. I hope you learned a lot today, and here are my references. Thank you.